Hi, welcome back guys. Today we'll be looking at section B of paper 2. If you haven't already, I'd check out section A. We've just done that. Anyway, let's get straight into it. Now before we get onto some of the main topics of section B, it's probably good to have a look at these keywords and words you might not know that will probably come up throughout this paper. So firstly, you've got burden of proof, an obligation on a party in a court case to establish the evidence to a required degree. So in civil, this burden, for example, is on the claimant. You've also got standard of proof, which in civil is on the balance of probabilities. You've also got special damages, general damages. Fault-based torts that will come up in this paper are negligence and occupiers liability. And the strict liability torts are nuisance, Rylands and Fletcher, and vicarious liability. It's in the public interest to provide moral and just outcomes. It's fair and balances the interests of both parties. Also, nuisance is failing to do something which a reasonable person would do or would not do. So you don't have to write that down. It's just, if you don't already know it, you should probably add what you don't know. So the first topic that comes up on the spec is negligence. The first test for negligence is duty of care. So duty of care originated in Donahue v Stevenson, where Lord Atkins stated that the neighbour principle. We owe a duty of care to those who can foreseeably be afforded by our acts and omissions. This was extended by Caparo v Dickman to the three-stage test. So this is as follows. Was damage or harm reasonably foreseeable? The case I use here is Kent v Griffiths. Is there a sufficient proximate close relationship between the claimant and defendant? I use Borhill v Young here. And is it fair, just and reasonable to impose a duty? So the floodgate argument is used here as there's too many claims, so it enables judges to limit them. So I use Alcock v CCSY, the Hillsborough case. Test 2 for negligence is breach of duty. So if duty of care is owed, then you have to work out whether it's been breached. So to do so, we compare the deed to the reasonable man to see if they'd act in the same way. So the general standing is the reasonable and prudent man. So Blythe v Birmingham Waterworks is the case there. The standard for children is lower. So Mullins v Richard, the case there. A standard for experts/professionals is the standard of the reasonable pros in the same field following accepted practices. So I used Bolam v Fran Hospital there. And the standard for learners is the reasonable standard of a competent person. So I used Nettleship v Weston there. Test 2 continued. Secondly, you've got the degree of risk that has to be taken into account. So the risk must be foreseeable, unlike in Roe v Minister of Health. So the risk factors that are considered here are the likelihood of harm. So I used Walton v Stone. Magnitude of harm / special characteristics of C. Paris v Stepney Borough Council. And the cost and practicality of taking precautions. So Latimer v AEC Limited. And the potential benefits of the risk / social benefits. So lastly, I used Watt v Hertfordshire. Really, you can use any cases, but those are the ones that I've gone with. Lastly, test 3 is damage. So damage resulted to the sea from the breach. Some of the mini tests within damage are as follows. So firstly, you've got causation. The breach caused the damage. So you can use Barnett v Chelsea Kensington Hospital for the case there. Secondly, you've got remoteness. So the damage must not be too remote. There has to be maybe an element of foreseeability. So Wagon Mound is the most popular case to use there. Type of injury foreseeable. So if you could foresee the injury, it doesn't matter that you could not foresee the way it occurred. So the damage occurred doesn't have to be foreseeable. Hughes v. Lord Advocate. And lastly, the thin skull rule. So Smith v. Leachbrain. Moving on to the evaluation of negligence. Firstly, it's quite costly, as evidence, eyewitnesses and experts have to be gathered, which possibly is a deterrent to the claimant. Also delay. There's a 3-year time limit from the date of an accident to starting a personal injury claim. Insurance companies tried delaying tactics to make C give up the claim. You've also got establishing the duty of care. Courts don't like holding public authorities responsible and liable, so use a policy argument to avoid them. So, for example, the floodgate argument for Hillsborough. I've gone with ABC v St George NHS Trust here. Continuing the evaluation of negligence. So, another point of argument is policy. So, judges are becoming more likely to make policy decisions that go against precedent. So, courts doing so argue they're filling a gap in the law. However, it's argued that judges owe it to lawyers and the public to be more clear and consistent with the law, as it's confusing and misleading when established principles are so easily overturned. Some reform that can be suggested is to use compulsory insurance, like the US have, greater use of out-of-court settlements, and raise the lower limit of personal injury claims to £5,000. Now, something that probably won't come up, but it's good to take a note of because you never know, is this thing called res ipsa loquitur. It's Latin for the thing speaks for itself. So in some situations, it's difficult for the C to know exactly what happened, and it's obvious that there must have been some negligence. So in res ipsa, the burden of proof shifts to D. So test 1 is that D was in control of the situation which caused the injury. The accident would not have happened unless someone was negligent. And 3, there is no other explanation for the injury. So if C can show these 3, then the burden of proof shifts to D, who has to prove he hasn't been negligent. So the big case to use here is Scott v London and St Catherine Docks. Moving on to the other fault-based tort, you've also got occupiers liability. An occupier is described as someone who exercises control over the premises. So Wheat v Laken. Premises are described as a person having occupation or control of any fixed or movable structure, including vessel, vehicle and aircraft. I used Wheeler v Coppaster. And a trespasser is a person who has no permission or authority to be in the occupier's premises, or a visitor that has gone beyond their permission to be on the premises. Now, there's 2 sections to occupiers liability. Now, the first one is the 1957 Act, which corresponds to visitors. So, lawful visitors are an invitee, a licensee, someone with a contractual or legal right to enter. They are owed a duty of care under Section 2, Section 2.1, which is the Section 2.2, to see visitors are reasonably safe in the premises for which they are invited. To check that the work has not been done by an independent contractor, Section 4. Section 2.4, that damage is caused by faulty execution. The occupier can pass liability to the contractor. Check the visitor was not exercising his calling, Section 2.3b, Rolls v Nathan. Are there any children in the scenario? Section 2.3, because the occupier must guard against allurement. Glasgow Court v Taylor, the case where there was poisonous berries in a park and children ate them. Moving on to the 1984 Act, which refers to the trespassers. Tests be proved to hold an occupier liable for a trespasser. So duty is owed for injury on the premises by reason of any danger due to the state of the premises or the things done or omitted to them. So that comes under section 1(1)(a). So the occupier should take reasonable care appropriate to the circumstances to ensure trespassers are not injured. Factors considered are the natures of the premises, the degree of danger, the practicality of taking precautions, the age of the trespasser. So duty is only owed if the occupier is aware of the danger or has reasonable grounds to believe it exists, knows or has reasonable grounds to believe that the other is in the vicinity of the danger concerned or may come into. Lastly, the risk is one against which the occupier may be expected to offer the other some protection. So trespass is continued. Under adult trespassers, the courts have introduced the idea of obvious dangers. So Ratcliffe v O'Connell. The time of day and the year are actually relevant when determining duty of care. So Donahue v Folkestone properties. The occupier doesn't have to spend lots of money to make the premises safe. So Tomlinson v Congleton. The occupier is not liable if he has no reason to suspect the presence of trespassers. So Higgs v Foster. And the occupier isn't liable if they're not aware or had no reason to expect the danger existed. So Rind v Atsby. And for a child, the same statutory rules are applied, as seen in Keown v Coventry NHS. Now, defences to a claim by a trespasser, you've got con-neg, consent, warnings, so Ray v Mars for that. Moving on to the evaluation of occupiers, the 1957 Act is more generous in terms of what can be claimed for as damages. So the 57, you can claim for property and personal injury. However, the 84, it's only personal injury that you can claim for. Also, the compensation awarded to trespassers is more limited. Lord Hoffman, in Tomlinson v Congleton, said this is because it's unduly burdensome to require landowners to take steps to protect. The rule on obvious dangers also can be harsh. No duty is owed when the trespasser is injured due to an obvious danger. So you can use Ratcliffe v McConnell again. Both acts differ on the point of whether it's necessary for the occupier to have actual knowledge of the danger. So Rind v Atsby. 84 does require, but the 57 doesn't. However, both find it necessary to identify the particular danger before one can see to what the occupier's duty is. Edwards v Sutton. Lastly, not many seem to be awarded damages under the 1984 Act. It gives trespassers rights to claims, but judges seem to find reasons not to allow claims by trespassers. However, this reflects public opinion to not support a person who shouldn't be on the premises in the first place. Looking at reform, I suggested introduce no-fault liability so that the injured visitor, whether lawful or trespasser, should be able to claim compensation. However, the burden is on the occupier, so compulsory insurance is needed, which could be seen as unpopular. You could have a state-run compensation scheme. So currently the government's following an approach of imposing a general tax on all insurance policies. However, the tax doesn't go towards property insurance policies incentives, so maybe it should. Also, you could change to an approach of personal responsibility imposed by judges despite rights. Judges imposed extra hurdles on claims by trespassers, with the result that now very few such claims by trespassers succeed. For the following strict liability torts, I've grouped nuisance and Rylands v Fletcher together, as they're both torts that are connected to land. Also, they're grouped that way in the spec. Starting out with nuisance. Nuisance is split into two. Well, there's two types of nuisance. So you've got public and private. So starting with private, private nuisance is the unlawful interference with a person's use or enjoyment of land, or some right over, or in connection with it. So the claimant is someone with interest in the land, so Hunter v Canary Wharf, and the defendant is a person causing or allowing the nuisance, so Tetley v Chitty. So you also have to consider if the interference is indirect. Common examples include noise, fumes, vibrations. The unlawful interference is insufficient on its own. It has to be unlawful, and this means unreasonable. So courts will ask to figure this out. In all of the circumstances, is it reasonable for the sea to have to suffer the interference? So the factors of unreasonableness, the courts will consider on the balance of interests to answer this question. Locality, so Sturges v Bridgman. Sensitivity, Robinson v Kilvert. Unusual sensitivity is not protected, however. Malice, Christie v Davey. Social benefit, Miller v Jackson. Duration, Crown River Cruises v Kimbolton Fireworks. Some of the defences you can use are consent, contributory negligence, statutory authority, planning permission, prescription. Some of the remedies, injunction, damages, prescription. So looking at public nuisance, this is something which affects the comfort and convenience of the public as a whole, rather than of an individual complaint. So a class of people depends on the facts of the case, and it's impossible to divide the precise number of individuals necessarily affected for there to be considered a particular class. Also, this is subjective to the judge. So this is AG v PYA Quarries is the main case for that. So here's the C&D. So you use the same notes that I used in private for that. When can someone make an individual claim in tort? So the C must be able to show that they suffered special damage over and above that of which other members of the class have suffered for a successful claim. So Castle v St Augustine. Now the types of damage that can be suffered are as followed. So personal injury. So C can claim damages of PI due to a public nuisance. So Corby litigation v Corby Borough Council. Damage to goods, Halsey v SO. And financial loss, Rose v Mole. The defences are consent, conneg, and statutory authority. And the main remedy is injunction. Evaluating nuisance. If D is doing something that has a social benefit, it's not always a defence to a claim. So what classes as a social benefit seems to be at the whim of the judge, and this subjectivity leads to inconsistencies. So you can use Miller v Jackson for that. There's also considerable overlap between nuisance and negligence. So this is quite confusing to have two torts covering the same issue. So for example, you can claim for personal injury and financial loss in both public nuisance and negligence. Nuisance is also an unfair tort because it's based in strict liability. Except in malice cases, the D can be liable even though they have taken great care to stop a nuisance happening. So Leakey v National Trust. Disputes between neighbours can also quickly escalate. So for example, murders. It shows the law is unsatisfactory and out of control, and the courts should encourage out-of-court ADR to settle these disputes more. The other tort connected to land is Rylands v Fletcher, 1868. So this tort actually comes from a case. So the tort covers situations where harm is done as a result of something dangerous escaping from neighbouring land, and when the D brought the dangerous material onto his premises and accumulated there. So the claimant is a person with interest in the land, so Hunter v Canary Wharf again, and the defendant is an owner or occupier of the land. So the tests for this are as follows. Something has been brought onto the land. That thing is likely to do damage if it escapes. So Howe v Jennings. The thing is a non-natural use of the land. So Cambridge Water, you can use for that. And also the activity needs to be non-naturally added. The thing escaped. So British Celanese Hunt v Hunt. Also, the damage has been done, that was foreseeable. So Cambridge Water you can use again. Now, defences you can use for this are Act of God, Act of a Stranger, Valenti, Contributory Negligence, Stat Authority, and you can have damages for remedies. Evaluating Rylands v Fletcher. Firstly, it's quite difficult to prove. Lord Khan added the non-natural use requirement, which made it even harder. Restrictions and defences limit its usefulness, as claims are easier to defeat. Secondly, the tort has not developed how the original concept developed. Difficulties in a tech age of demonstrating non-natural use of land. Judges have shown hostility to the RVF use, restricting its application. So this was shown in Ricards v Lothian, where a judge said it must be a special use of land, bringing with it increased danger to others. Also, Reed v Lyons, only liability if thing brought onto the land escapes from that land. Reform for Rylands v Fletcher. So, the Pearson Commission in 1978 released a report that recommended it be replaced with a clearer statutory scheme for injuries suffered in hazardous activities, which required those who engaged in them to pay compensation for injuries caused in true strict liability actions. So, for example, the Reservoirs Act 1975. Now, the next topic is vicarious liability. Vicarious liability arises when an employer can be sued for the acts or omissions of an employee where they amount to a tort. So it's justified by ensuring those best placed to meet the cost of legal action take responsibility for the acts/omissions of those for whom they are responsible, and they're often insured, so they're more likely to be able to pay compensation. So the person committing the tort is the tortfeasor. Now it's important to use these technical terms. So sometimes you can shift liability if there's an independent contractor involved in the case. So if the employer does not take care in selection / check his work, they may be liable. This is primary rather than VL. Primary liability means the employer is sued due to his/her own negligence, rather than the negligence of the employee, as shown in Hasseldine v Dorr. The duty owed by the employer is non-delegable, so the employer has a duty and cannot escape liability by delegating that duty to someone else. Test 1 for vicarious is akin to employment. So in order to be vicariously liable for the acts/omissions of another, it must be shown that the D and the tortfeasor are in a relationship of employment, or as illustrated in Barclays v Vicarious, akin to employment. So the case of Ready Mixed Concrete v MOP established the now commonly used test for establishing who is liable. So the test is as follows: whether the work is done in return for a wage, who controls the work done, who pays national insurance, and who supplies equipment. Test 2 is the course of their employment. So the tortfeasor must be an employer rather than an independent contractor. So the tortfeasor must be acting in the course of their employment. So this means the tort must be sufficiently closely connected with that employment. So the case I use here is Mohammed v Morrison's. Secondly, the C must prove the employee had committed a tort, so the usual rules, standards, factors of that tort apply. Liability can also apply for authorised acts carried out in a wrongful way, as shown in Limpus v London Omnibus. The employer is or can be liable for employees travelling to/from work if this is time that's paid for, as illustrated in Smith v Stages. The employer may avoid liability if the employee is acting on a frolic of his own, so i.e. acting in his/her own interests rather than the employer's. So you can use Rose v Plenty for that. A good way to remember this point is authorised act in an unauthorised way. Recent rulings have overturned the approach to what comes within the scope of the employment. So now courts also consider the closeness of the connection between the nature of the employment and that tort. So Lister v Halsey Hall you can use. Test 2 continued. Assault can be included in VL. Also, the Court of Appeal held employers can be liable for authorised acts done in the wrong way, or for unauthorised acts connected with acts the employee was authorised to do, if they are deemed to be methods of carrying out the authorised acts. So these kind of notes, you only really apply the ones that are relevant to your case that you get in your exam, because I know there's quite a few, you don't have to remember all of them. So some of the defences are contributory negligence and consent, and the remedies are special damages, pecuniary damages, and injunctions. Now looking at the evaluation of Vicarious, VL places responsibility on the employer to compensate victims of tort caused by their employers whilst acting in the course of their employment. So thus, if the activity is outside of their employment, such as if an employee is on a frolic of his own, they're not accountable. Employers should have robust internal disciplinary systems, and this is fair to hold employers liable. However, you could argue a point of injustice, as Vicarious places liability on employers when an employee doing something they're explicitly told not to do. Secondly, it ensures victims receive justice, so compensation is more likely to be paid, as they're in a better financial position. Also, justice for victims is more important than justice for employers. Also, they have insurance, so they're not really punished. Although it seems unfair for employers to take all responsibility when an employee is acting dangerously/carelessly. The case I used there is Century Insurance v Northern Ireland Transport Board. VL only places liability for those under a contract of service, i.e. employers. Unfortunately, over the years, courts have laid down several tests in order to establish whether someone is an employee or not. So, for example, you've got the economic reality test in ready-mix concrete. It makes the law complicated and inconsistent, which leads to injustice. One test only might provide an employer too much flexibility, so it may encourage subcontract to avoid. This leads to the employment stability effect, which is detrimental on society. Allowing them to avoid liability when they direct, monitor and control the work is immoral. Lastly, it has to be a close connection between the tort and what the employee was employed to do, which puts an onus on monitoring employees firmly on the employer. So disciplinary action, training if dangerous practices occur. The case which is really good to use here is Lister v Halsey Hall. So they should have ensured that they had robust procedures in place to monitor behaviour of staff. However, it could be argued their decisions are harsh, as it's not the warden's job to molest. Reform and conclusion. So I suggested statutory reform, so a statute to clearly lay out the extent of an employer's liability potentially simplifying the law and preventing inconsistencies and uncertainty. You could also say state-run compensation. So to conclude, the rules of VL are extensive and complicated, and this causes injustice. However, the justifications outweigh implications, although Parliament should clarify, really. Employers must continue to be held accountable for their employees. Morally, VL is good as it ensures employers conduct safe business practices. The imposition of VL is fair on employers. This means they're more robust and diligent, and employers' liability is limited, as it should be. The next topic, remedies. So starting with the most common remedy is injunctions. This is a court order, either to prevent D from doing something or to force D to do something. So you've got a prohibitory injunction, so this prevents D from doing something, a mandatory injunction to force D to do something, and a partial injunction to limit or reduce activities. So it might be good to remember some of the cases for the specific injunctions there, as that will stand out in the exam. The next remedy is abatement. So this usually means entering D's premises to prevent a further nuisance. So this usually comes from a court order, or it doesn't have to all the time. So C enters D's garden to chop down an overhanging tree, and the branches need to be returned to D in order for it to be within the law. Looking at damages next. The aim of damages is to put the C in the position they were in before the tort committed against them. So this is split into two types of damages. Firstly, you've got special damages, which are losses precisely identified, so for example from receipts. Then you've got general, non-pecuniary, so things that don't have precise monetary value, so like cost of injury, pain and suffering. And pecuniary, so future financial losses, so like earnings, medical, travel. Now damages can be paid in many ways, a few being instalments, lump sums. Now moving on to defences. The following includes where defences are used, so where they can be used, essentially. So it might be good to take a note of this. So the first defence is contributory negligence, which is a partial defence. So the amount of blame will be decided by the judge. The judgment will firstly set out the full amount of damages, as if there was no contributory negligence. The judge will then decide the percentage that C is responsible for, and then reduce the full amount by this percentage. So from the Butcher, as a case to use it. You've also got Valenti, which is consent. So defence will not succeed where the claimant has no choice but to accept the risk. Consent in medical cases does not require a detailed explanation of remote side effects. So Sidaway v Governor's BRM hospitals. Acting against employers' orders / statutory guidance means Valenti is likely to succeed. Before the defence can be applied successfully, it must be shown that the defendant did in fact commit a tort. So there's quite a few ones for consent here. You've also got moving to a nuisance. So Sturgis v Bridgman, DR built a consulting room in their garden land next to a confectioner. The noise interfered with D's ability to see his patients, and it was no defence that D had been established first. You've also got prescription. The fact that the C moved to the nuisance is not a defence, but it is possible for a person to obtain a prescriptive right to carry on an activity that, in the eyes of someone, amounts to a private nuisance. However, the activity complained of must have been continuously carried out for at least 20 years. Throughout that time, it must have been actionable as a public-private nuisance, but nobody has in fact taken action. So Sturgis v. Bridgman. Statutory authority. So the nuisance is created by a public body acting under a legislative duty or power. As long as the activity is carried out without negligence and with reasonable regard to and care of the interests of others, C cannot sue in nuisance, as the nuisance has effectively been authorised by Parliament. A statute may impose a duty on D to accumulate the thing which has escaped. Therefore, prima facie, a D is not liable if the escape occurs during activities authorised by an Act of Parliament, provided negligence is not involved. Act of a stranger. So D is not liable if the escape is caused by the deliberate and unforeseen act of a stranger. So Rickards v. Lothian, the flooding case. Act of God defence. So if a natural event is so enormous that it cannot be either foreseen or guarded against, it acts as a defence. So the issue is not whether the event could be anticipated, but whether human prudence should have foreseen the possibility of the event and guarded against it. So Transco v. Stockport, unforeseeable natural phenomenon involves no human agency. It's good to remember one of those quotes for that defence. Some other defences that don't really fit in anywhere. You've got express or implied consent of C to presence of source of danger. If the source of danger is maintained for the benefit of C and D, then D is not liable for escape. And the escape fault of the claimant means no liability, so Ponting v. Noakes. Now that brings us to the end of Section B and as a whole Paper 2. I hope you found this useful. Leave a comment if you've got any questions and I'll try and get back to you again. Anyway, thanks for listening. I'll see you next time.